And my name is Pam Wilbur, and I'm your room host for this session. Today's presenter is Catherine Johnson. Catherine received her Bachelor of Business degree, Juris Doctor, and Master's in Higher Education degrees from the University of Iowa. Prior to joining the great team at Disability Rights Iowa, Catherine's work included serving the Assistant Dean of Students at St. Louis University School of Law, the Director of Student Legal Services at the University of Iowa, and a disability rights attorney at Disability Rights Center of Kansas. Before coming to the Executive Director of DRI, she was the Director of the ADA Resource Center for Equality and Accessibility at the University of Kansas. Catherine has devoted her career to impactful civil rights works on behalf of individuals with disabilities. Welcome. Yes.
Thank you for that lovely introduction, and thank you everyone for coming out bright and early to learn about the ADA and 504. I'm going to try and go through some of the history behind these laws, explain to you how these laws impact our lives and where you can use them and where you can't, and how these two laws overlap with each other. So if you have any questions as I'm talking through these slides, please just indicate a question and we'll stop and make sure to get that answered right away. Okay, let's go on the first slide. So first off, Section 504 of the Rehabilitation Act of 1973. This law has been getting a lot of attention recently. So is everyone aware of what's been happening with 504 recently? Okay. Well, this law is actually 50 years old. It is from 1973. It is the first ever federal disability civil rights law. When Congress passed this, it was to really look at disability civil rights, equal access to federal agencies, federal employment, and looking at the requirement that federal employers provide reasonable accommodations. So 504 of the Rehab Act only applies to federal agencies or agencies that receive federal funds. So if you as an agency receive Medicaid, Medicaid is federally funds, then 504 applies to you. Schools, this applies to schools. All public schools receive federal funding. If a private school receives federal funding through a reduced lunch program, that is a federal fund and 504 applies to them. Some private schools don't have any federal funding at all, and what that means is 504 protections for students with disabilities and employees with disabilities would not apply to that private school. But the organizations that this applies to are really vast, so it's anyone who receives financial assistance or federal funding from the government. And so we have a list here of things that people don't think of sometimes. So it's all agencies through the Department of Health and Human Services, hospitals, nursing homes receive Medicaid. They're subject to 504 protections, mental health centers, human services programs, and we've talked about the public and private schools. And then it does not apply to any agency that's not a federal employer, not a federal subcontractee, or an agency that doesn't receive any federal funds. So if you're in that situation where you're advocating for your rights against let's say, just say, for example, a private school that receives no federal funds, if you try and argue that your rights under 504 of the Rehab Act have been violated, the school would promptly and correctly tell you 504 does not apply to them. So that is an important distinction to know. You want to have credibility with whomever the entity is that you are trying to assert rights on. And if you assert the wrong law, you then have to go back and say, well, okay, that was the wrong law and here's the right law that applies. Let's go forward. So what 504 protections mean is it's a civil rights law to say that federal entities and those that receive federal funds cannot deny qualified individuals the opportunity to participate in and benefit from federally funded programs, services, or other benefits. That's a lot of gobbledygook of what the law says, but essentially what it means is a person with a disability has the right to have equal access to every program service that a federal entity or a federally funded entity provides. You cannot be denied access to program services, benefits, or the opportunity to participate in those programs. You cannot be excluded because of a physical barrier. So buildings that only had steps, for example, had to be modified to under 504. You cannot be denied employment opportunities. You cannot say to somebody with a disability, I'm not going to hire you because you have a disability. You can't say to somebody, I'm not going to promote you because you have a disability, right? You can't fire somebody with a disability. That's all against protections in 504. You also, as an employee in the under 504, have the right to ask for what's called a reasonable workplace accommodation to be able to work, right? If you have a job duty that you have trouble doing because of a disability, you can ask for that job duty to be modified so that you can do it, and that's the reasonable accommodation process. You also have the right under 504, if you can't have access to a program or a service, to ask for an accommodation under 504. So a really good example that does happen still, because some of our buildings are really old and haven't been modified, is that you might have, let's say, a class in a high school building that is up on a second floor, and that's only way to get there is through stairs. Let's say you cannot get up there on the stairs. You can ask as an accommodation for that program, that class, to be moved to the first floor so it's accessible to you, okay? That is program access under 504. Okay, let's keep going. So 504, and I wanted to kind of outline this because when people think of 504, what they know most is 504 plans through education, right? And that is a right to have a plan developed that helps that student have equal access to school and all the programs that the school provide. That's really different than an IEP under a different federal law, which is the IDEA. So 504 plans are not generally as robust as an IEP. They don't have special education components to it. They're more oftentimes health related. They say somebody with maybe asthma or diabetes that needs maybe breaks from school, or they need to have food with them, and that violates rules. You know, there's plans that can be put in place under 504. So 504 is broader than that. It includes employment, right? So if you're a federal agency or a federally funded, you cannot discriminate based on disability in any employment, right? You also have to provide reasonable accommodations. The program accessibility that we just talked about, you cannot put the only program that you're providing on the third floor that has no access through elevators, right? You have to think through that. What is program accessibility? It applies to the elementary and secondary education. That's where the requirement to have equal access to education comes in. That's where the 504 plans come in. Post-secondary education, this is something that probably many people don't know, but the Rehab Act applies to all students and all employees in, I would say, most universities, because most universities receive federal financial aid. That's federally funded. That subjects those universities to 504. So that allows you as a student to ask for academic adjustments in your program. Can also ask as an employee for a reasonable accommodation under 504. Most people don't do that anymore because of the ADA. They'll look to the ADA, but both of those laws apply to people in that situation. You could use both of them or one of them. Health, welfare, and social services is also covered. This is a brand new section. The health, welfare, and social services did not used to be formally part of 504. This is some of the controversy that's been going on in the news recently about the lawsuit with 504. The 504 rule was updated and amended in the Biden administration. I'm trying to think, maybe 2 years ago, I think, maybe 3. And it added in health, welfare, and social services very specific requirements for those agencies that receive federal funding, such that if you're a person with a disability and you go to a health clinic, the clinic has to have a scale that you can use, regardless of if you can walk on the scale or if you roll on the scale. It has to be available to you. They also are required now to have exam rooms that raise and lower. It used to be, I've had so many clients over the years tell me they've gone in for their well woman exam and they're not able to transfer onto the table, and the doctor will just look at them and say, I think you're fine. You don't have any cervical cancer, you're fine, right? Go away. I've had clients die because they were not given those exams. So these are serious and good protections that are now outlined in the law. So this is some of what is being fought over in the lawsuit. But this is new, the health and welfare protections. The ADA already requires hospitals that are county hospitals to provide that, but it wouldn't apply to a private hospital. So that's why 504 is really important. If that private hospital receives Medicaid, which most hospitals do, 504 applies, and those protections are there. So that's 504. That was the first civil rights law. You can see it's pretty broad, but it only applies in this really narrow category, right? It's federal agencies and people that receive federal funding, right? It doesn't apply to the rest of the world. So about 34 years ago, there began to be a movement that we needed a comparable 504 to the rest of the world, right? To all the private employers, all the private entities, all of the gyms and the restaurants and the concerts that we want to go to, all the fun stuff in life was not accessible, right? So there began to be a push for the Americans with Disabilities Act. And when Congress began looking at this, the very first thing that they did is did a big study about what life was like at the time that this was happening. So this was late 80s that this was going on. What they found is generally across all states in the United States, there was a lack of access to public buildings and bathrooms. So the ADA really changed that. The world we know now is really different. Back before the ADA, was not required that you had a ramp to get into buildings, right? A lot of buildings just had stairs. Sometimes there was an accessible entrance, but it might be way in the back, in the alley, kind of hard to get to, right? ADA really changed that. Bathrooms were kind of an utter nightmare before the ADA, not accessible. Again, I've had many clients I've worked with over the years that weren't able to leave their house to work because the bathroom wasn't accessible. So what we kind of take for granted now has really radically changed. Denials of educational opportunities across the board. Students were not being educated. Students were being turned away from school, saying, nope, we don't have to help you. You're not educable. Go away, right? There wasn't a law in place that required schools to provide that access. Absence of accessible transportation. This is one that the ADA really changed. So 504 didn't really address transportation, but the ADA did. All of the buses now have to be accessible, right? There's still some issues with Uber and the lifts and all those kinds of things, but the buses have to be accessible. Planes have to be accessible, right? Trains, et cetera, et cetera. The Congress found there was an alarming rate of poverty. There was a huge educational gap. A lot of students with disabilities were either being kind of pushed out of school or were dropping out of school because of lack of access. And a life of social isolation. And I have found this within the clients that I've worked with over my career that it tends to be a large amount of time spent at home by yourself. And that is really, really sad. The ADA sought to change that and make the world more accessible. And I think it has done a good job. There's still issues, that we need to keep working on, but it has been a radical change in our society with the protections under the ADA. We'll go to the next slide. I think we might be, do we go backwards? Okay, so this is kind of some of what the Congress findings were. So they found that 20% of individuals with disabilities lived below the poverty rate, or lived below the poverty rate at that time. That was ×2 from the population of people that did not have disabilities. 40% of individuals with disabilities did not graduate from high school, 3 times higher. 29% of individuals with disabilities had some college, 48% higher than that without a disability. 2/3 of working age adults with disabilities were unemployed. 1/4% were full-time. I don't know the stats on this 100%, but I don't think this has changed all that much, unfortunately. This is an area that we need to keep working on. 2/3 of individuals with disabilities had not attended a movie or a sporting event in the past year. And you got to think about the world at the time, right? It was late 80s. Nothing was accessible. Would have been very difficult to get out and attend anything. And this to me is one of the best things that the ADA has done, is made our world more accessible. So we all can go to these fun events that make life worth living, right? You want to go do the fun stuff you want to do. 3/4 of the individuals with disabilities did not attend live theater, music performances, or go out for dinner at a restaurant. So again, all the stuff that truly makes life worth living, not able to do because it wasn't accessible. So now that has changed. And this one always kind of gets me. 13% of individuals with disabilities had never in their lifetime gone to a grocery store. Now, sometimes people say, oh, that's great, I hate shopping, right? But don't you want to go independently to the store and pick out your own food? Like, I know we all lived through COVID. We had our food delivered. I personally hated that. I'm one of those people that I want to pick out the apple myself, right? And everyone should have that right. So the ADA changed that. Okay, let's keep going. Okay, so some of the advocacy around getting the ADA passed started in 1990. There was a Wheels of Justice campaign in Washington, D.C. Thousands of people came to D.C. to put pressure on Congress to enact the ADA. They marched to the White House. If you've ever been to Congress, it's kind of daunting. You go over there and there's about 8,000 steps that you have to go up to get in there. And some people that had rolled down in chairs said, hey, we are not going to take this. And they got out of their chairs and they crawled up the steps. This made a big impact on Congress and the ability to get the ADA enacted and passed at this time. And so this movement became known as the Capitol Crawl. Some people got arrested. Let's go forward. There was a young girl that got out of her chair and climbed up these steps that if we can watch, I think if you click on that, you should be able to, we'll try to watch this. This is Jennifer Keelan. I think she's now about 25 or so, but at the time I think she was 12 maybe. But let's listen to Jennifer. I hope it plays. Do you see the arrow? You should just be able to click. Oh no, that's okay. Or if that doesn't work, you can try the YouTube link also. That's what I did first. Oh, okay. Oh, I can't even. Can you get back to the PowerPoint? Yeah, it doesn't like that. Yeah, try just clicking on that and see.
It's like it's not live.
It's not, okay. Okay, well, this PowerPoint will be sent out to everybody so you can watch it. It's about a minute long video, and Jennifer talks about that day. And so here's on the other side, it's a picture of her on the day climbing the stairs, and she talks about the power of her advocacy and how she wasn't going to take no for an answer. She wasn't going to let those stairs stop her from getting up there to let Congress know they had to pass this. And so she did. She climbed all the way up. She had in her back pocket some information that she gave when she got to the top. And everyone that was there from the media really was kind of taken with her and her advocacy. She was very young. Like I said, I think she was 12 or so. But she made a difference just by being there and saying, no, this is unacceptable. I am going to make a change. We'll keep going. So the ADA was signed by President Bush, July 26, 1990. This was a comprehensive civil rights law. Congress had certain goals in mind when they enacted this. It was for all individuals with disabilities to have equal opportunity to participate in all parts of life, right? Everything, not just those federal agencies anymore. This covers everything. Private companies have full participation in all parts of life, have the ability to live independently, right? And again, this is important to keep in mind that at the time that this was passed, there was still a large part of our community that was living in institutions. ADA gave you a right to live independently. This is different and new and exciting. And also the right to have economic self-sufficiency. This means having a working wage and a job, right? And the right to have that job. So this includes employment, public services, which are state and government and county services, public accommodations. A public accommodation is any business that is open for business, essentially. It's any place that you can go that you don't have to be specifically invited into, right? So shopping, restaurants, theater, movies, events, concerts, gymnasiums, all that is a public accommodation, and they have to provide accommodations and have to ensure access into those buildings. One of the things that used to really bother me a lot is there are certain stores that when you go into them, the store is so cram-packed, you cannot get through, right? So like I'm thinking one that comes to mind is like Joann Fabrics. Has anyone ever been in that store? Yeah, it's tight, right? I mean, I think it's hard to get through that if you're using a wheelchair for mobility. It's challenging, right? So that store has been subject to litigation about lack of access through their store. So things like that you don't think about, the ADA applies and says you have to be accessible. Telecommunications, at the time when this happened, we all used landline phones, and they were not accessible, right, to people that were deaf. You couldn't use a phone, right? So the ADA thought about this and said, we have to develop a telecommunication system that is accessible to people that are deaf and hard of hearing. And so they required a relay system. Now this, over the years, has really changed. I haven't had a landline phone in about 30 years. I don't know if everyone here has, but we all text, right? And we do different things now. So the telecommunication requirement under the ADA is still present because the ADA hasn't gotten rid of it, but it's not as, I think, needed because we have different ways of communicating now that's just inherently more accessible than it used to be. Okay, let's keep going. So the ADA and 504, this kind of confuses people because, as I said, both of these laws interact. Both have very specific protections and apply to very specific things. But sometimes you can use both of them at the same time. So for students that are in high school or grade school, both of these laws apply to you. And you would have to decide, do you want to go under both of them and ask for an accommodation or ask for access? Or one? Is one law better than the other for you? And that really depends on what the issue is that you're trying to address. A private doctor taking Medicaid is only going to be subjected to the protections under 504. This is why the health protections that the brand new 504 rule has in it are so important, because the prior rule didn't have that. The Rehab Act had not been updated for about 50 years. And so that the new rule is very detailed when it comes to access to health care. And then a county hospital is only going to be required to follow the ADA under Title II. They're a county entity. But the protections in the new 504 for health access are exactly the same as what Title II of the ADA requires. Title II and 504 also now have really strong requirements to address full inclusion of people with disabilities into all program services that are covered by those different entities. And they also have to provide effective communication. The other thing that the updated 504 rule did is try to take what has been known in the ADA for years as the right to live in the community of your choice with appropriate Medicaid services and supports. 504 made that part of the new rule. That said you have that right to community inclusion or community integration, right? That did not exist before. Okay, let's keep going. So one thing I wanted to address, because I think this is confusing to a lot of people, is we have so many different federal disability rights laws, and they all apply to different things. The 504 plans for education are well known. I think the IEP is also pretty well known. IEP is not part of 504. That is part of a different federal disability rights law, that's IDEA. So IDEA applies to you, as does 504, in school up until graduation time. After you graduate from high school, IDEA stops. If you go on to additional vocational training or additional college, the IDEA does not come with you. And that is really a shock for a lot of the students and parents that I've worked with over the years. They think that IDEA continues to apply and you get all the same educational supports and services that you did when you were in high school. That's not at all the same. But the ADA and 504 rights apply to you after high school. So they have what's called an academic adjustment under ADA and 504. So you can ask for accommodations, academic accommodations. Instead of an IEP plan, you're asking for academic accommodations. Keep going. So some examples will sound similar to things that probably happened in high school in an IEP plan, but it's changes in a course requirement. So sometimes people have difficulty, let's say with math, and math fits a certain requirement for a program. We all have trouble with math, right? My dad's a math professor, so I was never able to say I had trouble with math because I had a built-in instructor. He's like, no. But I know a lot of people have difficulty with math. So you can ask, as an academic adjustment, to have a substitute for math with a different logic. Normally math is considered a logic course, so I want to take a different logic course. That would be a process. The university would have to prove it, but that's an example. More time for a test. Reducing a course load. Some universities and vocational programs have a requirement that you take, let's say, 4 classes at a time, right? That's what they consider to be full-time. You can ask to have that reduced based on disability needs. You can ask to register for classes first. And you can see this is kind of an older accommodation, if you will. So when I was in college, we actually had to stand in line outside of a building to register in person. I know everyone's looking at me like, what? No, so the online system did not exist. Yeah, do you have a question? No? No? Okay. Yeah, the online system for registering didn't exist. But even within that system, you can ask to be the first to register online. If you needed extra time to register, you can ask for that. If you need to make sure you get a certain class, you can do that. Note takers, you can ask to have a note taker. You can ask for the professors to share their lecture notes with you. Yeah, yeah. Oh, hold on one second. Let me get you a. You want to make sure to pick up for this.
I was just wondering if the academic adjustment would still apply for like a one-on-one associate.
A one-on-one, like an attendant care person, you mean? No, that is a really good point. So that is something that you can get in under the IDA, is that one-on-one kind of para support. That is not something that the ADA or the 504 would require a university to provide. So great question. And actually it kind of leads into my next slide. You can go ahead. Okay, so just quick, a couple other things. You can ask for a course to be recorded. That through a recording device. You can ask for ASL. I've seen a movement now to ask to attend courses virtually as an accommodation. That used to be something that no university was set up to do, but with COVID, a lot of universities still have that ability, and they'll allow you to Zoom in to a course if you need to. Okay, let's keep going. So, but what's not required is the personal attendant, what the question you just asked. It's also personal mobility devices are not required. So the things that students were used to getting under IDA through an IEP plan, a lot of those are considered personal equipment, personal needs that the 504 and the ADA specifically say are not required anymore. And that goes both for school, like higher education, but also for any accommodation you would ask for. Like if you would ask your employer to provide a mobility device for you, they would not be required to do that. If you would ask for an attendant care to help you at work, they would not be required to do that. So it's different. That's why it's really important to know what the law is before you go and ask for something. Because if you go and ask for it and they say no, if they say no correctly, you're in this position of you don't know that they've correctly denied you, right? And then you might file a complaint and spend a lot of your energy and time on something that you didn't have the right under the law to ask for. So it's important to know, so you use the right law and just know what you can and can't ask for. You cannot ask to lower or change the courses or the requirements that are needed for a degree or graduation. This is kind of back to school. So if you have to take 90 hours to get a certain degree and they have to be in these different areas, you can't say, well, could I ask for an accommodation to take 70 hours instead? You can't do that. You can ask for more time. Like if they say you have to take 90 hours in 4 years, you can say, well, I can't do that. Could I have 6 years? That would be a reasonable accommodation. You can't ask to change degree requirements. So if you're getting, let's say, a degree in English, but you have trouble passing some of the courses because of the requirements in that course, you couldn't say, okay, I want this English degree, but I don't want to take any of the required English courses that I have to take. I instead want to take Spanish as a substitute, right? That they would not let you do that. And we talked about personal attendants and personal mobility devices. Okay, let's keep going. So I think, okay, good. So the Americans with Disabilities Act, this is just kind of a summary of how this applies. So it requires police stations to be accessible and follow the ADA, schools, both post-high school, high school, grade school, kindergarten, have to follow the ADA. The courts have to be accessible. We have a lot of calls from people that go into courts and they ask for an accommodation from the judge, and the judge says, no, I'm not going to do that. Well, that's a violation of their rights under the ADA. They have a right to ask the court for an accommodation. Oftentimes, this is somebody that's asking for American Sign Language interpreter for their hearing, and the judge says, I don't know anything about that. You would think a judge would know what the law is, right? But they often don't. And so they deny it. We get a lot of calls about things like that. Parks have to be accessible. So the ADA has a really large document that looks at all the different places the ADA applies to and has created what are called architectural standards. There's a whole chapter on parks. This book is about this big. There's a whole chapter on bathrooms and what a bathroom has to have to be accessible. And it's very, very technical, but it's really clear what you have to do to comply with the ADA. Workplaces have to be accessible and have to provide reasonable accommodations unless the accommodation is going to cause an undue burden to the employer. Typically, an undue burden is the accommodation costs too much money. Most accommodations don't cost any money at all. So when you look at denying that for cost, it has to be something really astronomical, like someone coming in and saying, I need you as the employer to build an elevator in this building. That could be a couple $1 million. That's not going to be reasonable, right? But I need a different kind of keyboard, or I need a different kind of chair. Going to be reasonable. Public transportation, we talked about that, it has to be accessible. And then all state and local government services have to be accessible. So this is any type of disability, the program has to be accessible. So we've talked about wheelchair accessibility. There's a requirement to have permanent signs be brailled. Service animals have to be allowed in. Again, this is another area that we get a lot of calls about that I'd be happy, Karen, someday to come back and do a service animal presentation. There's a lot of confusion about service animals versus emotional support animals, therapy animals. But a service animal is an animal, a dog, or a miniature horse that's been individually trained to perform a task on behalf of a person with a disability. It's a task that helps that person with a disability perform their task during the day, right? It's not something that the dog's been trained like to go fetch a ball or something. It's not like that. It's disability related. But if that animal meets that definition, it is a service animal and cannot be denied as long as it is under the control of the handler. If you try and bring a service animal in that's barking, jumping on people, having accidents, then the business would be entitled to say to you, your service, your dog, your animal is not under your control. Could you get it under control? If you can't, they could ask you to remove that animal, but not you, right? Which gets tricky if you're there with your service animal. But they can only ask the animal, if it's not under control, to be removed. And then listening devices. This was something that the ADA kind of thought through. It was not something that 504 under the Rehab Act really even considers. So a listening device, there's a couple of different types of listening devices. The most common are the ones that you wear around your neck, and it's like having a microphone that's attached to a hearing aid. And the sound from me, if I was wearing one right now, and let's say if Zach here had a hearing aid, he would hear everything in his hearing aid that I was saying. That is the least expensive listening device, but that is required it's required to have certain number of them in like an auditorium kind of setting. If you're a large space and you're doing a large conference, the ADA says you have to have what's called a different kind of system that essentially provides the sound directly within the room, directly to everyone in that room's hearing aids. So it's called a looping system, and it's generally a cable in the floor or in the ceiling, and there's microphones, and it's on all the time, and it goes directly into a hearing aid. And it is the most expensive, but it's also the best way to provide assistance for communication through listening devices. Let's keep going. So some advocacy tips here. I think I'm doing okay on time. We've kind of been talking about this a little bit throughout, but I think it's really important before you start advocating for your rights under any law that you know where that law applies to you, what you can ask for under the law, and what there might be in terms of a limitation of your rights under that law, and whether or not that law is actually the right law for you to be asking, right, using to advocate for yourself. We've only talked about 504 in the ADA. There's probably 10 different federal disability rights laws that I would recommend you know about, but I don't have time to cover all 10, but these are really significant rights that you should definitely know about. I would advocate for whatever plan it is. I'd be really clear in my head, what am I trying to get? What is the access that I'm being denied? How am I going to go about this? The best thing you can do is make sure that you're formalizing your request if you're asking for access. So you don't want to just call and say, hey, I need to have an accommodation. I'm coming in for a doctor's appointment, right? I need more time with the doctor than 5 minutes. I need an hour, right? Let's say that's your accommodation request. If you don't write a letter or document that more, whoever took that message, you're counting on them to get the message to someone who can make a decision. So you can count on that never happening, probably, right? Because you'll go to your doctor's appointment and you'll say, okay, I've got an hour. That's what I asked for. I never heard back. I assumed it was fine. And they're going to say, we have no record of that, right? So protect yourself with how you're asking for the accommodation. And then practice. I think it's really hard the very first time you try to advocate for yourself to feel comfortable doing that, right? Even for me, I am really comfortable. I'll advocate for all of you, no problem. I'll get you everything you need. If I try and ask for something for me, it is hard. It is really challenging because I have to be vulnerable to ask somebody for something. That feels scary, right? So practice. Practice with a friend, family member. Have them be the person you're asking that from, and go back and forth and role play that a little bit so you're more comfortable when you ask the stranger. And then you need to plan ahead for some accommodations. Some accommodations take time to put in place. And an American Sign Language interpreter is a really good example of this. Most places don't have on staff someone who's fluent in ASL. So if that's an accommodation you need, you have to ask, I would say, minimum of a couple weeks ahead. It depends on where you live, but sometimes it's very challenging in Iowa to find people that are available for ASL. They're not a lot of ASL interpreters, and you want to make sure that you have adequate time for whomever it is to find somebody. And I would say you should always advocate for your rights. We have powerful rights under federal law. These are not things that you should feel like I'm asking for a favor, or am I going to use this law and someone's going to be mad at me? Too bad, right, if they are. These are your rights under the law, and if we don't use them and educate people about them, they will go away. Of that I can tell you. So you need to advocate, you need to know what your rights are, and be powerful and asking for what you're entitled to under federal law. I think that might be my last slide, maybe? Oh, no. Okay, I was premature. So nothing about us without us. This has long been our motto as the disability community, right? It basically says, don't make any decisions about me and my community. Let us make that decision. Let us be a part of that decision. You, without disabilities, don't know what we need or what's important to us. We need to be at the table when those decisions are being made. So we're a powerful community. There's 61 million of us in the United States. That is 26% of the population. That number does not include people that have long COVID. Long COVID is a new disability. So if you have long COVID, you're covered under the Rehab Act and under the ADA.
What is long COVID?
That's a great question. So long COVID is a condition that some people that had COVID resulted in having. It's a permanent medical condition that can cause fatigue, it can cause muscle weaknesses, it can cause cognitive impairment, and among other health things. So it's something that as a result of having COVID. Not everyone that has COVID has long COVID, but a few people have. And it does leave people in varying stages of impairment. So I've worked with people that have had long COVID that will faint unexpectedly, get dizzy, are not able to walk very far without being really fatigued, and have trouble working. So it kind of depends. It's a varying symptoms. But great question. 1 billion people worldwide, so that's 1 in 7, identifies having a disability. In Iowa, we have over 400,000 Iowans that identify as having a disability. We have these federal disability rights laws. We've been talking about 2 of them today and a little bit about the IDEA. These are powerful laws with powerful rights attached to them. The other thing about the disability community is, you know, we as a community are powerful when we are together and we advocate together. When we splinter off and try and have infighting about who has the right disability or whose disability is more significant than other disabilities, we lose our power. So it's really important that as a disability community that we stay together, advocate together. And the reason I say that is I see this time right now as really important for our community to stay together and advocate strongly about some of the rights that are being attempted to be taken away from us. So I don't want to get political on you, but I think this is a time to be a forceful community for our rights. So the power of the disability rights advocacy, it's up to all of us, right? One person is never going to change the world, but a community that is 6 million or 61 million in the US, 400,000 in Iowa, you can see the power, right? If we're all advocating together to protect our rights, we're strong. No one can take our rights if we stand together and have a very powerful voice and message about the importance of our community. So questions? I think that is it, right? Yeah. Anyone have any questions? Yes. Let me give you a microphone.
Can you maybe talk a little bit about what's at risk with the lawsuit? Is it overall Section 504? Is it a part of it? I guess maybe some clarity on what's at risk here.
Yes, that's a great question. So right now, there was a joint status report that was filed by the 17 states that brought this suit, I think 2 weeks ago, maybe. And in that joint status report to the court, all 17 states said they no longer are seeking to have 504 found unconstitutional, which is good. But they are continuing with the suit. They're continuing to challenge the new rule on 504, which includes the health rules that we talked about and the access to health care, clinics, social services. They're continuing to challenge that. They're continuing to challenge the gender dysphoria argument that they believe that that is now part of 504. They're continuing to challenge that. So the lawsuit continues. The most extreme remedy that they were seeking has been let go, which is good. But the lawsuit's not over. It continues. It's still something to follow, to advocate against, to make sure that we're understanding what's at risk. If we lose the 504 protections that were just put in place a couple years ago, we lose a considerable lot. Like I said, the 504 has not been updated for 50 years. So we go back to a law that is 50 years old, that doesn't include a lot of the protections that are needed in today's society. I think the next status report will be in 2 or 3 months. There's been no hearing on this. The judge isn't ruling one way or another on these status reports, but they come in and they're noted. Any other question? Looks like we have about 10 minutes left. Yes. Okay, let me get 1 second here.
So this is a little bit more of a comment, but I think it's a really good example. So for any of you who have not met me yet, my name is Elizabeth. I work for Ask, and I am a blind person, which means I was a blind student. So when our presenter was talking in detail about going to register for classes early, I had this really sweet deal when I was in school where I would get to register with the seniors, which was great for me because it meant I got to pick the classes before all the classes were gone and full. But the justification, right, was they needed additional time to make sure that my instructional materials were available in an accessible format, right? Whether that was Braille, whether that was on my computer, whether that was an audiobook. So finding ways to, I always say, be creative in your justifications can go a long way, especially if you have a really good team on your side. So I guess that leads to a question. When you're working with educational agencies or schools, you know, post-secondary or otherwise, do you have any tips on keeping that good communication open so that that relationship stays healthy so that you can have those open conversations?
Yes, thank you, Elizabeth. That is such a good question. You know, I have found over my career that when you advocate with any kind of school system, it's really a different kind of advocacy that you need to use because you're going to have a long-term relationship with that entity, right? Whether it's your high school or your college. And at some point, that entity will become part of your advocacy, right? Because they're there to provide you with services and supports. So I always recommend that you start more gently, maybe, with this kind of entity than I would with maybe a private business that you're never maybe going to see again, right? So I always go in, I tell all the students I've worked with to go in with your list of what you're wanting. Like, you need to spend time, you need to understand what academic accommodations you're asking for, bring the proper medical documentation to support those requests. Go in, if you can still meet in person, that's what I think is best. Talk to your academic support counselor or whatever their title is. Explain what you need. Be knowledgeable. They're there to help you get this done, right? Make sure you understand whatever process they want you to go through. So you've done that. Sometimes that delays things. But go in with the idea of, you're part of my team. You're the expert here. This is what I need. I need you to help me with your expertise, get it done, right? Because that's what is going to be the most impactful to the person who's trying to help you. If you go in and say, you don't know what you're talking about, you're violating my rights, I hate you, you're evil, right? And I've had people do that. You're never going to get anywhere. Now, you have rights. If they deny you stuff, you can challenge them, you can go through complaints, you can go through different processes. But in the meantime, you're spending your valuable school and your education time fighting for rights I should have given you, right, to begin with, fighting for those accommodations. So I think even though it might not feel like advocacy, it is advocacy. You have to make a friend of that person. They're part of your team. So this is even more true in secondary school. You have this IEP team that can include 20 people, right, with the different experts that they bring in. Try to think of that instead of a scary entity with all these school officials saying no to, as a team of experts that have gathered to help you figure out your unique, individualized educational plan. And if you shift that and try to treat them as, you're the expert, I think this is what I need, right? And get them to understand what you need and have them agree to it, that is the best way forward. If they won't, again, you do have a right to challenge that through all kinds of complaint processes, but I know how stressful those are as a student and as a parent. They take over your life. So I think if you can use a softer approach, you actually get a lot farther with the teachers. The thing you have to keep in mind with teachers and educators is that they strongly believe they're the experts in all things related to you and your program. And if you don't let them keep that identity, they feel very disenfranchised and they're going to push against whatever you want because it's not something that they think is right. So that was a long answer. I don't know if that helped at all. I see you nodding, so I think you might agree with me. Yes, Alex, let me come over to you. Excuse me. Yes.
So I will say that I'm very appreciative of at least the physical accommodations that can be made in public spaces or in schools or all different kinds of places, businesses, etc. But I know that it can be expensive to make those accommodations at times, to develop ramps on the front of buildings, or to be able to make some of those adjustments. Are you aware of any funding mechanisms, grant programs, tax write-offs, or just exceptions, things like that, where people can find those types of things? Because I work with a lot of businesses that want to be more accessible, but owning a small business, let alone a storefront, and trying to make those changes, it doesn't rise to the level of importance as just keeping their doors open might be, or paying their employees. And so I'm always trying to look for money that would be public money that would be available, because it's in the best interest of all people, rather than playing hardball like you were saying with, I believe it was Elizabeth, her question. Yeah.
Yeah, that's such a good question. Unfortunately, no, I'm not. You know, the ADA has very specific requirements, but the ADA does not contain a funding mechanism to get that done. And that's especially true for private businesses. For state and county entities, they are required, when actually back to 504 days, to have what's called a transition plan to come into compliance with the ADA and 504. And that was looking at like a long-term, we know, let's say we're a city, right? We know our sidewalks don't meet the requirements. They don't have curb cuts. We know that some of our buildings are not accessible. You're supposed to develop a plan and begin to fund those slowly over a period of time. For a small business, that's not part of that. They don't have to have a transition plan. And I definitely understand the problem of trying to keep a door open, keep people paid, and do accessibility at the same time. The only thing I can say is that I don't know of any grants. It doesn't mean they're not out there, but I don't know of any personally. But I will tell you this, the power of the community when it comes to spending money is high. And so people with disabilities will go to stores that are accessible, right? And so that is something that businesses, instead of thinking of the cost to doing that, think of it's a short-term cost, it's a one-time cost with a long-time gain of income, because you now have a brand new customer base that will be loyal and will come back to you time and time again. Yeah. Elizabeth.
I was just going to say untapped potential.
Untapped potential, right. I think that's really true. Yep.
Well, you said the city has to adjust its infrastructure for that. Can they account for businesses too?
Oh, for sure. Yeah, for sure. Yeah. Yeah.
So, like asking the city for assistance?
Yeah, I mean, you certainly could. I mean, some cities may have funding available for help. Some may not. Hold on, Alex, let me come to you. Yeah, I think it's exploring your community. Sometimes the commerce centers or Chamber of Commerce might have some money.
So one of the hats that I wear is I serve on the city council in Sioux City. And I know for our city, at least, we have what's called a facade program. And some people call it like a Main Street program or whatever, where maybe you have a different designated area and a business can apply to like make their storefront look better. Or maybe it's a brand new sign or a new door or something like that. And I do know, whether it was because of my urging or if it was already a part of it, that they allow push buttons to be a part of that facade program. And usually that means, hey, if you will pay $1,000, we'll give you $1,000, or type of thing. Like there's a cost sharing in different cities. And so if your city has a facade program or a program to beautify the storefronts, that might be a mechanism. I know we do that extensively in Sioux City.
Yeah, that's a great thing. Yeah, so check with your city or your county and see, you know, what they can provide for help. If you know of a business that's not accessible and you want to bring that to their attention, I mean, a good way to do that is just by a letter of introduction that I'm a potential customer. I want to buy things from you, but I can't get into your store, or I can't get access through your store, whatever the situation might be. and see if the business responds. I think people are looking for new customers. You know, everybody wants to have a successful business. I think that businesses don't think about the fact that if they make some small changes, they might bring in a whole new customer base. So that could be really important for them to know. I think it sounds like we're out of time. Well, thank you all. I'm doing another session at 1 that will be on this kind of a similar topic. So come back at 1 if you want more.